All right, we're on. Welcome, everyone, to the Charity and Security Network webinar, The False Claim Act, of What Nonprofits Need to Know. This is the first in a new series of webinars that the Charity and Security Network will host, addressing targeted legal actions against nonprofits that are engaging in humanitarian, peace building, and other work in global hotspots. Today's webinar is being recorded, so please note during the question and answer session that the recording will be posted on our website and available to the public. And keep that information in mind if you choose to identify yourself and your organization. There is a chat box in this webinar tool that also allows you to submit questions. I would like to review a little bit of the background on what got us here before we welcome Brian Waagner of the law firm Husch Blackwell to tell us in detail about the False Claim Act. We learned this spring about 3 cases in which the Zionist Advocacy Center had sued NGOs under the False Claim Act. 2 of these cases were settled, and one against the Carter Center was dismissed on motion of the Department of Justice. All of these cases allege that the NGOs involved had provided material support to terrorism, which violated the anti-terrorism certification clause they signed when they got their USAID funding. That makes the definition of material support very relevant, and you see here on your screen the material support definition from the criminal statute that prohibits not just tangible and monetary assistance, but also intangible things like training, expert advice and assistance, and services. The law does not require that the support be intended to support terrorism, and USAID's position is that the certification that an organization has not provided material support in the past 10 years apply to all of its activities in the past 10 years, whether funded by USAID or not. Many of the executive orders in the U.S. that name organizations to the terrorist list also include the language prohibiting material support to them. So the issue of material support is relevant to all these cases, but it's also one that nonprofits are generally familiar with. The vehicle for these lawsuits, the False Claim Act, is not as familiar, and that's why we have Brian Waagner here today to explain it to us. Brian is a partner in the Washington, D.C. office of Husch Blackwell and is the leader of the firm's government contracting practice group. He will provide expert guidance on the False Claim Act itself, how it has been applied in recent years, and how it affects USAID contracts and grants. Later in the month, we hope to do a separate webinar on USAID Office of Inspector General investigations and information requests, where Brian's colleague at Husch Blackwell, Singleton McAllister, will give us a presentation. She is, or was, the General Counsel of USAID from 1996 to 2001, and is an expert in grant administration at USAID. So watch for that in the future. For now, I will turn it over to Brian to fill us in on the False Claim Act. Then I'll take the moderator's privilege of asking the first 2 questions, and then we'll look for your questions as well. Thank you. Brian?
Great. Thanks, Kay. So why don't we flip over to my first slide, substantive slide. What I'm going to talk about is really sort of a very high-level overview of what the False Claims Act is, what it does, how it works, and what you can expect if you are doing business with a federal government agency, a United States agency such as USAID. The False Claims Act was first enacted in 1863 as a result of Civil War contractors engaging in fraud against the United States, contractors that were selling ammunition and transportation services and other things like that. There was a series of hearings in the United States Senate at which the Congress was outraged by the behavior of these contractors against the United States. And so we put a statutory regime in place to raise the stakes for contractors that are engaged in fraudulent activity. So that law has been in place since 1863. It's been expanded and updated and everything since then many times, and it's still today the primary crime fraud fighting tool that the United States uses in its business relationships with outside private enterprise. In essence, the False Claims Act makes it deems a violation whenever a contractor tells a lie in order to cause the federal government to make a payment of money. You see here on slide 4 the definitions from the statute itself. If a contractor knowingly presents or causes to be presented a false or fraudulent claim for payment or approval, or knowingly makes, uses, or causes to be made or used a false record or statement that is material to a false or fraudulent claim. That's the underlying violation, the sort of the burden of proof that the government has in establishing a False Claims Act violation. If a False Claims Act violation is established, then there is a basis for the government to recover penalties, as well as penalties of $5,000 to $10,000 per violation, and that could be any time you submit a certification that is deemed false. So it could be an invoice, it could be a voucher, it could be any sort of statement. And in certain categories of cases, the penalties can be quite significant. The other thing the False Claims Act does is it allows the government to recover 3 times the amount of the damages that the government suffers. So if the government has $100,000 worth of damage, the False Claims Act statute would allow the government to recover $300,000 back. Let's go over and go to the next slide. I have a few definitions that I want to talk about. The first one is, what is a claim? A claim, in essence, is anything that is a request to the government to pay money in some respect, or some document that is connected to the submission of a request for payment. So it could be an invoice, it could be a statement such that for which you're expecting reimbursement. It could be a wide variety of things. The definition of claim, I'm not aware of any case that suggests that you can win a False Claims Act case simply because you haven't submitted a claim. The definition is very broad. The other aspect of this definition is it applies not only to contractors or grantees who submit claims directly to the federal agency, but also to subgrantees and subcontractors who submit claims upstream to a grantee or a subgrantee. If there is an expectation that the government will eventually reimburse the fees or the costs that are submitted through that payment request, then you would face False Claims Act liability. It isn't limited merely to the first tier of grantees or contractors. Go ahead and go to the next slide. The second thing is the definition of knowing and knowingly. So in order to tell a lie, you have to know that there's something false about what you're saying, right? So in the False Claims Act uses this term knowingly and defines the term knowingly to be broader than simple actual knowledge. So you can be telling a lie if you have deliberate ignorance of the truth or the falsity, or if you're engaged in reckless disregard of whether the statement is true or false. So it's important to distinguish this sort of knowing standard from the criminal liability standard. There is not a requirement that the government establish that you intended to defraud the government. The knowing standard is simply that you knew or should have known that the statement that you were making to the federal government is false. Let's go to the next slide. And then the other term, and I'm going to talk more about this term later because we talk about the Supreme Court's decision in Escobar. The statement, the false statement, has to be, in order for liability to attach under the False Claims Act, the false statement has to be material to the government's decision to make a payment or not make a payment. So this is a definition that has been in the statute a long time. It's basically a common sense definition. Would the truth or falsity of the particular statement have an influence on the person making the decision to pay? Would it cause them to make the payment or not make the payment? If they knew you were in violation of a contract clause, or if they knew you were violating a particular provision in the contract, would they have made the payment or not? And if you concealed that fact, would it have made it more likely that they would pay? I have a long discussion about this topic because this was the focus of the Supreme Court's 2016 decision in Escobar. Let's go ahead and go to the next page. So I've talked about a couple of definitions. The next thing that I want to talk about is the qui tam provisions of the False Claims Act. So obviously, if you submit a false claim, the United States would be able to bring an action for violation of the False Claims Act. The qui tam provisions of the statute, 31 U.S.C. 3730, allow a private person to bring a False Claims Act case in the name of the United States. So essentially, these are the whistleblower provisions. They allow a private person who brings a case to bring the case in the name of the United States, and then if the case goes forward and there's some recovery, the private whistleblower can share in the recovery. In a case in which the government takes over, normally what would happen is the private whistleblower would file the case. The government would have a period of time to investigate the case to determine whether the government was interested in it, whether the government saw merit in the case or not. And then the government would have a decision to make about whether to intervene. If the government intervenes, the government actually takes over the case. And in most cases, the whistleblower would sit and wait for the outcome of the case to be resolved, and then would receive a payment out of the proceeds of the settlement. In cases when the government intervenes, the whistleblower would be allowed to recover somewhere between 15 and 25% of the proceeds of the action, plus attorney's fees and costs, reasonable attorney's fees and costs. In cases when the government does not intervene, the statute authorizes the whistleblower to proceed with the case on its own, basically to stand in for the United States and proceed with the case. And if there's a recovery there, the whistleblower could recover somewhere between 25 and 30% of the total recovery plus attorney's fees and costs. Now, in nearly all cases, when the government does not intervene, the case goes away. Whistleblowers are not often in a position to bring those cases and proceed on them without the support of the United States. Let's go ahead and go to the next slide. One of the things, I just added this slide in recently in response to a question that I received recently. And one of the things that we've noticed about the TZAC cases against the USAID NGOs is that in the ones that we've seen appear to be based on news reports or public media disclosures. They would say, for example, I found on the internet that your organization has received the following grants, and they would list the number. And this is available through, public internet sources. And then they would say, and I know because I read the regulations that when you sign one of these grants, you have to execute the ATC certification, and I have photographs of you doing business with somebody who is on the excluded persons list, and so I know I suspect, to a strong degree of likelihood that you have made a false representation to the government regarding your compliance with the terrorism certification, and so therefore you submitted a false claim. And that's sort of the allegations in all three of the cases that we saw. Normally, a case like that would not be a basis for a whistleblower case. The United States obviously has discretion about whether to pursue those cases, but in most cases, when you're talking about information gathered from public sources, the whistleblower would not be able to participate as a whistleblower. They don't have standing to bring the case as a whistleblower, and they can they bring the case to the government's attention. The government, of course, has the authority to investigate and make a determination about whether there's merit in the case and to bring the case on its own. But if the government doesn't intervene in the case and pursue it on its own, then the whistleblower case would, in my view, be subject to a motion to dismiss and ought to be dismissed. And so this is the statute that gives you that authority to dismiss the case on the basis of that original source requirement. Let's go ahead and go to the next slide. So I mentioned the requirement for materiality. So let me back up a little bit and talk about the two different types of certifications that we're talking about that can lead to False Claims Act liability. One is sort of an express certification. You know, I certify that I did 100 hours of work. And if you didn't do 100 hours of work, well, obviously that would be a lie. That would be a violation of the False Claims Act and a violation of express certification. Then there's the implied certification concept, under which you say, I did 100 hours of work and I'm entitled to payment. And by virtue of submitting an invoice, you make an implied certification that whether or not you said anything or not on the invoice about your compliance with all of the regulations and all of the certifications and all of the requirements of your contract or your grant, you make an implied certification that you're in compliance. So up until 2016, whether that was a viable theory of liability under the False Claims Act was subject to a split in the circuit courts of appeal in the United States. There were some circuits that said, you know, you've invoiced for 100 hours, you said you did 100 hours of worth of work, you haven't made a statement as to whether you were in compliance with the regulations, so therefore we don't have a basis to say that you would be in violation of the False Claims Act. Other cases say, well, you submitted an invoice, and so by virtue of submitting an invoice, you make an implied representation that you're in full compliance with all the requirements of your contract, and you make a statement that you're in compliance with all the requirements that led to the formation of your contract, et cetera. And so by submitting that invoice, if any of those violations are false, you've been in violation of the False Claims Act. You've made a false implied certification. The trouble with that was that it allowed whistleblowers, as you can imagine, whistleblowers were allowed to essentially second guess the decisions of the parties to the contract or parties to the grant. So you could say, perform a contract or a grant with the United States for 10 years without trouble, submit invoices, receive payment without any sort of difficulty, and then a third party comes along. Typically, it would be a disgruntled former employee, somebody who disagreed with sort of the company policy on certain issues, would bring a case and say, I have inside information that this company was not in compliance with certain requirements of the regulations. And they would bring a case and they would recover, they would be able to have the court decide whether there was whether the compliance was material or not, and whether it made a difference in the outcome of the case, in the outcome of the government's decision to make payment. And in some cases, you have government officials making decisions about whether to make payment, and then years later, you have the United States Attorney's Office making a different judgment. You have a disgruntled employee making a different judgment, and the ultimate, determiner, the ultimate authority on whether an implied certification was submitted or not, a false certification was submitted or not, was a jury in a federal court somewhere in the United States. There were lots of people who thought that was unfair. The contractor community was among those people, and so the case ultimately made it to the Supreme Court. The question of whether this implied certification liability was appropriate, whether it was contemplated as a remedy under the False Claims Act, et cetera, made its way to the Supreme Court in 2016, and this is the case of Escobar versus Universal Health Services. This was a mental health clinic in Massachusetts who housed a patient, a 12-year-old girl went to live there, and she lived there for 5 years until she was 17. And when she was 17, while living in the clinic, she had a seizure and then died. And following the investigations that came out, it turned out that the clinic in which she lived had not been in compliance with its regulatory requirements for its doctors and nurses to be properly accredited. The physician, the prescribing physician who gave this girl medication was not actually did not have prescribing authority. She was a nurse who did not have authority to prescribe medication. The psychologist who was treating this girl in her therapy practice was a psychologist, and she had a PhD, but it was a correspondence degree, and it was not from an accredited university. So there were instances like that where the individuals that were working in the clinic did not have their certification to provide the medical care that was being provided to this girl. Her parents, based on information they got from the investigation that was conducted following this girl's death, filed a case under the False Claims Act, and eventually it made it to the Supreme Court. And the Supreme Court is presented with the question, is the implied certification theory of liability under the False Claims Act a viable theory, yes or no? The Supreme Court, in a rare unanimous decision, this was June of 2016, there were 8 justices involved in this case. The decision came out shortly after Justice Scalia had died, so there was not yet a 9th justice who had been appointed to fill his position. So it was an 8-0 decision written by Justice Clarence Thomas. And this is the key holding, the language that you see on the screen here today. This is the key holding from the Escobar case. The implied certification theory is a basis for liability, but the court decision puts a strong limit on the availability of false certification liability. First of all, it can't just be an invoice in which you state that you are requesting payment. You have to make a specific representation about the goods or services you're providing. In the Escobar case, this was a Medicaid reimbursement program under which the medical clinic that was providing the services used a provider identifying number, which carried with it a reference to the state regulations for identification of providers and certain the qualifications of providers. And they also used codes that were established by the federal government's Medicaid program, which identified the nature of the services that were being provided, and a reference to, and then with respect to that number, identified all of the services that were supposed to have been provided in connection with it. So there was a specific representation, even though they didn't make a qualitative representation in words, they used codes in the invoices that linked their regulatory compliance to the services that were being provided. So the second component of the decision, of Escobar, first you have to make a specific request, specific representation about their goods or services. Second, it has to be material to the government's decision to make a payment. And as to what material is, let's go ahead and go to the next slide. We have a few references in the opinion to what material means, and there's a long discussion of what material means. The main issue from the contractor's perspective with the implied certification theory prior to Escobar was that it allowed whistleblowers to second guess decisions that contractors and contracting administrators had made about whether a contractor's compliance with the regulation was material to the decision to pay or not. So for example, you're doing business for 10 years, you interpret the contract to mean A, the government interprets the contract to mean A, you submit invoices, you receive payment, everything's good. A whistleblower comes along, and now you have, through the vehicle of the False Claims Act, you have the ability to have a jury come along and second guess that and cause the contractor to not only repay what it was paid, but repay in, with treble damages applied to it, plus attorney's fees. So there was a significant concern among the contractor community that this was not fair. So Supreme Court's decision puts some limits on that. It says implied certification is a viable theory. It still allows the whistleblower to bring those cases, but it specifically says that minor or insubstantial compliance is not enough. So it's not simply you failed to comply with a collateral regulation. It should be, your failure to comply should be something that is significant, something that goes to the heart of the requirements that are set forth in the grant or the contract. The Supreme Court uses the word demanding. It is a demanding and fact-intensive requirement. So it's not just simply that the certification was one of many certifications that you're required to make, and it's not simply that the certification the contract says something like failure to comply with this certification will be justification for termination of the contract. The fact that it says that is not necessarily determinative of whether a representation is material or not. Ultimately, what we're looking at is, in terms of determining materiality, what we're looking for is how did the government treat this particular case, and how would the government respond to this if it had known of the falsity of this requirement. So we see many, many cases where the government learns of a particular non-compliance, but deems it not important enough to worry about. It's more important to get the work done than to insist on picayune compliance with all of the umpteen regulations that may apply. So in my view, it eliminates the ability for these third-party whistleblowers to come back and second guess the decision making that is made by contractors and government officials in terms of administering a government contract. Let's go ahead and go to the next page. So there have been over 100 court decisions addressing the implications of Escobar since it was decided in June of 2016. And in almost all circumstances, not all, but in most circumstances, the result has been that the defendant, the grantee or the contractor or the person that had sought payment from the government in the first place comes out ahead as a result of the application of Escobar. And I've got two cases cited here just to illustrate the magnitude of the impact of Escobar. Harmon v. Trinity Industries and Ruck v. Salas Rehabilitation. Those were two cases in which juries had returned verdicts against the contractor for significant money. In the Trinity case, it was a $663 million jury verdict. The Fifth Circuit overturned that case and entered judgment for the defendant, citing the rationale for Escobar, which was simply that, the False Claims Act is not a vehicle by which third parties and juries can overturn decisions with respect to compliance with a government contract or with a specification that's laid out by the government. Same thing with Salas Rehabilitation. This was a case, it was a $350 million jury verdict in that case. And a lot of these cases are actually getting resolved. I mean, these two cases are resolved after the jury verdict. Now, if you're on the defense side of one of these cases, no one wants to, have the case be pending so long that you can have a jury verdict entered and then win the case on appeal. You'd much rather win the case early on, as early as possible. And there have been many, many, many cases across the country granting motions to dismiss by defendants to say that there isn't anything in the facts alleged in the complaint that would support the conclusion that the government, upon learning of a particular instance of noncompliance, would have continued to withhold payment. Cases granting summary judgment for contractors and grantees, etc. So it's been a very powerful tool in dealing with this implied certification requirement. And it's, in my view, it's a game changer for terms of how contractors can expect to respond to allegations of false claims and what they should do with respect to the administration of their contracts and grants. Let me go with a couple of additional slides. Go on to the next one. So Escobar influences, my sort of approach and the approach that I think contractors and grantees ought to take with respect to potential False Claims Act allegations. So Escobar says that the materiality is resolved in cases in which what we're looking for is how would the government respond to knowledge of a particular non-compliance. So what we're trying to do is we're trying to avoid any confusion about the scope of a contractor's particular compliance regime. And we're trying to make sure that there isn't any gaps in performance of the work. We're trying to make sure that there isn't any disagreement on the interpretation of the contract, et cetera. So with respect to the anti-terrorism certification, what you would be looking for is a detailed compliance plan. You would want the government to understand what your compliance plan was. You would want to make sure that your employees were trained, your consultants and subcontractors were doing what they are required to do under their anti-terrorism certifications. You would want to make sure, if there was any confusion on your part as to whether the anti-terrorism certification was applicable, whether your vetting process was adequate, whether it had extended to certain instances of grant compliance, you would want to address that with your contract administrator, your grant administrator, and make sure that they agreed with you that what you were doing is appropriate. The scenario you want to avoid is a situation where you uncover an instance of non-compliance and then you decide to bury it. What you're looking for is, if there is an instance of non-compliance, you would want to know about that, and you would want to make a disclosure of that to the government such that you can resolve it early as part of your ordinary contract administration, and that would essentially foreclose any. Certainly, there might be a False Claims Act violation that you uncover. My view would be it's much easier and much better to resolve that early on through the administration of the contract, through your contract administrator, than with negotiating with the United States Attorney's Office or the Relators Council in the context of a federal district court action somewhere in the United States. Go ahead and go to the next slide. So just a couple additional thoughts before we move into some questions. There's going to be a period of time in one of these whistleblower cases where the whistleblower files his case with the district court. The government then has a period of time to investigate and determine whether there has been a violation or not, and determine whether they're going to intervene in the case, whether they're going to pursue the contractor or not, and what remedies they're going to seek. It's possible that you would not learn about that investigation until much later in the game. It could be years after the investigation was undertaken before you ever learn about it. But in all likelihood, you would have some indication early on in the case that a case had been filed or that the government was conducting an investigation. So you would see, for example, a civil investigative demand, you would see a subpoena, you would see OIG correspondence requesting documents, you would see a call from OIG investigators to interview your employees. you could see OIG investigators show up at your employees' houses at night. This is something we've seen. They articulate that the reason they do that is because it makes their employees feel more comfortable and more free to talk. That has not been my experience. But nonetheless, there would be indications that the government is undertaking an investigation. So what can you do in response to that? Number one, retain counsel. An OIG investigation, one especially that's related to potential False Claims Act violation, is not something that you want to undertake without counsel. There can be lots of ways to engage in missteps when you're engaged in an investigation, and you want to make sure that you have experienced counsel on board who can work with the government investigators and make sure that they get what they are looking for, and there's not any confusion about the document request or the terms of the information that you're providing. The other side of it is your counsel can engage in discussions with the investigators to help you understand what the scope of the investigation is and whether there's any ability to sort of work through the issues in a proactive way. And during that process, there's going to be an exchange between your counsel and the investigators of the United States Attorney's Office, under which you could try to persuade them that there has been no false claim. Again, as we've talked about, you could persuade the government that the relator is not an original source. You could say there may have been an instance of non-compliance, but we did not know about it, so it was not a knowing violation. Has to be, as we talked about, it has to be a knowing violation. We talked a lot about the certification not being material. So, for example, if the government is investigating a violation of the anti-terrorism certification, but you've got correspondence with the grant administrator suggesting that they agree that your compliance program is adequate and that you have done an appropriate level of due diligence to make sure that there is no violation of that, then the idea that a case asserting a false claim for your improper administration of your diligence program, it would be much less likely to succeed and much easier to persuade the United States Attorney's Office that there really isn't a basis for a case. Then another thing is the sort of the damages question. This has been a topic in some of the appellate court cases that we've seen recently. The question is, when the government receives a false claim, what is the measure of damages? There have been some United States Attorney's offices that have tried to persuade courts that it's the value of the contract, or it's the value of a particular scope of work, or it's particular type of measuring damages that would be totally unrelated to the particular issue that's involved. There have been some recent cases that have suggested, no, the measure of damage is the difference between what the government paid for with a fully compliant contractor and what it received with a less than fully compliant contractor. And how that damage is measured can be important to the case. I mean, if the damage is very small, then the liability is also very small. So there's an issue for discussion in the context of the negotiations with the United States Attorney's Office, and that's a topic for briefing once the case gets unsealed and it's subject to litigation in federal court. Finally, there is a basis for a defendant on the receiving end of a False Claims Act case to recover attorney's fees under some circumstances. So I would not hold out hope for that. I would try to certainly get the case dismissed much earlier than that, and such that the attorney's fees that you spend in defending it are minimal if you can. But that is a remedy that's out there that's in the False Claims Act. Go ahead and go to the next slide. I think that's the conclusion of my slide presentation, but I think we have an ability to do some questions. And I think the plan is for Kay to start off with some of the questions that we've received in anticipation of this program, and then she's going to read some of the questions that maybe we've received during the course of the program, and hopefully I'll be able to answer them.
Thank you so much, Brian. It's very encouraging to hear that the Escobar case is a game changer. And being relatively recent, it may be something that would have made a difference in some of the cases we've seen so far. I have a couple of my own questions I'd like to ask, sure. And then we'll go to questions from participants. And please check the Q&A section and chat box, people, if you would like to submit a question. You've already answered a lot of the questions that I had, but one is I think it would be good to emphasize the difference between material support of terrorism and materiality as a technical term in the False Claim Act world, because the words sound so much alike, it gets kind of confusing about is it material whether or not you provided material support. Can you just kind of distinguish between the two just to make sure we're not confused going forward?
Right. So material support is the term of art that's used in that anti-terrorism certification, and it refers to the specific type of assistance or advice that you might be giving to people who are on the terrorist watch list, so to speak. So, you know, if you're providing support or expert advice to somebody who's deemed a terrorist, that might be deemed material support, and it would be deemed a violation of your anti-terrorism certification. That's the compliance element. Now, materiality is, in the terms of the False Claims Act, simply the term of art that refers to whether your compliance with the requirements of the contract were material to the government's decision to pay or not. So the material is part of the same definition, or same materiality is used in both, you know, contexts, but it does not mean the same thing, for sure. Something that is deemed material support of terrorism might not be material to the government's decision to pay, and vice versa.
My next question has to do with discovery, which is the term for information requests made between parties in a lawsuit prior to trial. If a False Claim Act suit goes forward, what are generally the rights of the government and the private party intervener to request information from a nonprofit, and conversely, can the nonprofit request information from the government and the party bringing the suit?
Yeah, so there's normally two phases of the False Claims Act case. The first one is the sort of investigation phase, and that's before the case becomes public, before it's unsealed and it turns into ordinary civil litigation. During the investigation phase, the government would normally be the one requesting the information. They would be the ones wanting to conduct interviews. They would be the ones who would be looking for documents to kind of put together 2 and 2 to determine whether there's a violation. During that phase, the grantee can be conducting its own sort of what I would call an internal investigation to determine its own exposure, for one thing, also to be able to assist the government in terms of resolving a particular factual question. A lot of times, government is strapped for resources in terms of doing these investigations and will accept a lot of assistance from the contractor or the grantee in terms of conducting its own investigation. So that's part one, that's the investigation phase. Part two is the litigation phase. So assuming that the investigation is concluded and the case is going to proceed, whether on the basis of the government intervening or whether on the basis of the whistleblower bringing the case forward without the assistance of the government, it's an ordinary civil case at that point, and discovery is permissible on both sides. Depositions, it's an ordinary civil case at that point. And American, the federal rules of civil procedure around discovery would apply. We certainly see people having trouble with that. It's certainly a difficulty for many, but the rules are fairly well established, and there isn't any confusion about them, at least.
The next question now comes from participants, which is you mentioned that disclosing violations that you may discover to USAID may help build a defense in a possible action under False Claim Act, that the payment, there was no materiality because USAID either agreed there was no violation or decided to make the payment anyway. But are there risks to be aware of in disclosing that information? For example, the possibility of a criminal prosecution for material support. And do you have any suggestions for navigating that difficult terrain?
So the way I see,
not an easy question.
No, it's not. And there would be, this is a situation where you would have lots of competing interests, because it might be that you have individuals who face criminal liability, the organization might face civil liability, and different people involved in the organization might face different issues. That's a question that has to be addressed on a case-by-case basis for sure. And to the extent that any individuals or different groups of individuals have different issues, everybody would probably need their own counsel, such that they were getting the best advice for their own situation. I can tell you that one of the things that happened before President Trump took office was Sally Yates, who was Assistant United States Attorney at the time, issued a memorandum, a policy memorandum that says the United States will not settle any civil case, including a civil false claims case, without understanding and evaluating the extent to which individuals would bear criminal liability. This was a reaction to the sort of the banking activity that led to the financial crisis in 2008, and there was a political perception that the banks suffered by paying damages and whatnot to the federal government, but none of the individuals who were seen as criminally responsible for engaging in fraudulent activity received any kind of punishment. So now you have a policy that is still in place that suggests that the government would be interested in looking at criminal liability associated with a False Claims Act. And it's possible that you could be in a situation where making a disclosure of a potential False Claims Act violation could open up certain individuals to potential criminal liability. So you would certainly, before you do that, you would want to make sure everybody is, on board with what the facts are, et cetera. Even if that's the case, though, I would suggest that the interest of the organization would suggest that you need to make that disclosure, because one, the failure to make the disclosure itself, even if there wasn't a basis for a False Claims Act allegation, if it's later determined that there should have been a disclosure and you did not make a disclosure, that can be a separate basis for debarment. And debarment is essentially a conclusion that you would no longer be eligible to perform U.S. government contracts or grants for up to 3 years. And if that's a significant component of your business activity, then that could be a significant cramp in your business lifestyle. So, I would hesitate to withhold a disclosure on the basis that it might reveal criminal activity, but certainly you would want to engage counsel for the individuals along with that disclosure. I don't know if that answers the question or not.
I think so. It's not a clear-cut yes or no answer situation. So, but it's helpful in thinking through what the analysis needs to be.
Yeah.
The next question is: are there any risks to be aware of when disclosing possible violations beyond the criminal possibility of criminal investigation? I guess that you mentioned debarment. Are there any others?
Well, so yeah, I mean, the government could, if in the event that you make a disclosure of a violation, obviously there's the debarment risk. There's also the possibility that the government could deem you in violation of the grant and seek some kind of compensation for it. The government could insist on having you adopt a very cumbersome and burdensome compliance program, strong oversight, but on balance, my view would be you're in almost all circumstances when you're dealing with the United States, the advice would be upfront and make the disclosure as soon as you can and make it as specifically as you can. You're much better off having made a disclosure and having worked through it with your contract administration professionals than you would be waiting a couple of years and seeing if anything happens, seeing if the United States attorney shows up in your office. They're not going to be as kind to you as your contract administrator professionals are.
But another question is, we know from the Zionist Advocacy Center statements that there are 4 more cases under the False Claim Act. They say they have 2 already in the court and 2 that they are preparing to bring. And as you noted, when those cases are first filed, they will be under seal. The defendants won't know about them. But are there any red flags that they indicate to an organization that a case is pending, and how long can a case be under seal?
Well, the red flags that I would point to, the sort of the obvious ones would be, the receipt of a document request from the OIG, an OIG investigator showing up at your offices or at your employees' homes, a telephone call from the United States Attorney's Office, any kind of informal document request. It could be a subpoena. It could be a wide variety of circumstances which you sort of put 2 and 2 together that the government is doing an investigation. And at that point, it's up to the recipient of the request to kind of put 2 and 2 together, try to figure out what's going on. And usually, if you are cooperative with the investigators and indicate that you're willing to cooperate and assist them in getting to the bottom of the issue, they will be cooperative and they will give you information about what it is they're investigating and how it is that you can help them get to the bottom of it. And typically, in our experience, provided you're sort of forthright on that side of the equation, it works out to your advantage, even if you're on the receiving end of one of these allegations. As far as how long the process can go along, the statute says that the government has 60 days from the time the case is filed by the whistleblower to investigate and make a decision to intervene or not. But it also says that they can seek additional time, quote, for good cause upon a request to the government. And these cases can go on, the investigation phase can go on for several years. We have been involved in some cases where the judge in a particular case will get frustrated with the government, and if the government can't convince the court that they're making progress, that the court will actually either order the case unsealed such that the contractor can file a motion to dismiss, or they will order the court, the United States, to take some kind of other action, either dismissing the case altogether or announcing their decision to intervene or not intervene. And so after a period of time in which the judge gets frustrated with them, that's really the only limit on the amount of time. It's the discretion of the United States District Court judge presiding over the case.
Oh, one ask now, you mentioned that normally publicly available information is not the basis for a whistleblower suit under the False Claim Act, that the private citizen would not have standing unless they have some unique information. What are your thoughts on why the suit against Norwegian People's Aid and American University in Beirut, which appeared to be based on publicly available information, ended up being settled and had a different outcome?
Well, the statute that talks about the requirement for the original source to bring the case does not preclude the government from conducting an investigation, and it doesn't preclude the government from initiating its own case, which is what I think happened here. they brought the case to the attention of the United States Attorney's Office, and even though in these cases the relator would not normally have standing to bring the case on its own, the government certainly has discretion to investigate and discretion to assert a claim against the contractor. And these contractors very likely would have had good defenses, but it is also an expensive prospect to defend one of these cases, and the consequences of having a False Claims Act case go to trial and possibly have a judgment entered against you for violation of the False Claims Act, especially something like the anti-terrorism certification, can be severe. And so you would think it could make sense. You put yourself in the situation of American University in Beirut or Norwegian People's Association. You can see why they would make a business decision to settle that case early rather than to litigate it for a couple of years, go to trial, and then hope for the best.
That's a particular problem of pressure on an organization. It needs to protect its ability to do its ongoing work, but there also may be allegations of activities that are claimed to be material support that really don't fit the definition of material support, and there might have been a defense based on that alone. And it appears the Zionist Advocacy Center's interpretation of material support is very, very broad, probably broader than what the U.S. government uses. I've got one more question. Invite people to send in a few last ones. You mentioned that the False Claim Act can extend to sub-grantees. How does that work in practice? Can the primary grantee be held liable related to sub-grantee's false claims?
So one of the requirements of the anti-terrorism certification is that if you award subgrants, then you would obtain certifications from the subgrantees. And so that's the way normally it would flow down. If the subgrantee is deemed to have made a violation, then the grantee can be held liable for the subgrantee's breach of that certification. So that sort of puts some teeth into the requirement for the prime grantee to do some diligence about whether the subgrantees are complying with this requirement. It isn't simply the requirement to check a box and say, you hereby certify that you comply with all federal regulations. If you're a prime grantee, you want to make sure the subgrantees have executed that certification themselves, and you want to make sure that they have a training program in place and that they are doing what they're needed to be doing to avoid making a false certification. Because if they make a false certification and then you pass through their request for payment to the government, then potentially you've made a false certification if there is a basis to say that you knowingly submitted the false claim. Right? Again, reckless disregard or deliberate ignorance, et cetera. It's a high standard. It's not just negligence, but the allegation could be made, and if a false claim is deemed to be submitted, you could be brought into the case, and then you're in the situation of making a choice that Norwegian people made of, settling the case or going to trial and hoping for the best.
One last question before we ask you to give us your final thoughts. Are any of these claims covered? Are they covered by professional liability insurance, either for liability or for legal costs?
That is a hard question. There is a divergence of authority on that question, and I have not studied it in great detail. I know that there are some companies have issued policies that contend that False Claims Act liability is not covered, and under some circumstances, there are some policies under which it would be covered. So I think the best answer to that question is it's a case-by-case analysis, and I think the strategy would be upon receiving some kind of indication that you have a False Claims Act allegation against you, you would definitely want to contact your insurance broker and look at your policies and get your counsel to give you some assessment about whether there's coverage. Because under some circumstances, you can get coverage for the defense of a False Claims Act case.
And one last question has come in. And why couldn't the Zionist Advocacy Center continue with the Carter Center case after the government refused to intervene? We know that DOJ requested the case be dismissed. Do you have any thoughts on what happened there? Because it's such a different outcome from the other two cases.
Yes. Number one is it's very rare that the government would actually move to dismiss. In most cases, the government would simply file a notice of non-intervention, and then under the statute, the relator would be able to pursue the case on his own. In this case, the government moved to dismiss, and the argument that they were making was that there wasn't any new information that the relator was going to be able to bring forth that the government didn't know about, and the difficulty of handling the defense of the case and dealing with document requests, et cetera, that would inevitably be presented through the course of that litigation was going to interfere with the government's ability to do business. And the court accepted that argument and dismissed the case. So there isn't any, basis for that case to proceed. And why that would have been different, you can see the different allegations. I mean, the allegations in the Carter Center case were quite a bit more picayune than the ones in the other two cases. So I could certainly see a substantive difference between the sort of the type of misconduct that was alleged in Carter Center versus those other cases. But, at the same time, it's possible that the government could simply say, look, we have enough resources to bring these types of cases. We understand what the allegation is. We are bringing our own authority to the table to pursue this case, and we don't need any assistance from you because, to be fair, he's really not bringing anything to the table that isn't already available to the government through its own resources. Right? As we said, he's using publicly available resources and internet sources to bring the allegations.
It sounds like a materiality issue may have worked to Carter Center's benefit there. The government was already aware of the activities. So, Brian,
yeah.
We're about out of time. If you could quickly give us any final thoughts, and then we'll put up a slide that has links to additional resources and invite people to check into the Charity and Security Network website and to watch for announcements of the subsequent webinars. Brian?
Yeah, the final thought that I would have is make sure that you are in compliance with your terrorism certification. If you're not, look at whether you need to conduct an investigation to figure out the full extent of your noncompliance and make a disclosure if you need to make a disclosure, and take action sooner rather than later. That would be my final word.
All right. Okay. And in the end, we know that all of the organizations working out there in very complex and difficult circumstances, there's no way that any organization, whether it's a nonprofit or bank or anyone else, can guarantee that everything will always go smoothly and perfectly and that problems won't come up. But the key point is to have systems in place to mitigate the risk of that to the extent practicable. And the key question of what is material support of terrorism and what appears to be an overly broad interpretation of that and by the Zionist Advocacy Center in its pleadings is one that still needs to be addressed. And we'll see what happens with the upcoming court cases. If an organization thinks that it may have a case under seal or it's under investigation, please feel free to contact us for information and resources that we are gathering so that no organization feels forced to settle under pressure unduly without having the resources it needs to mount an adequate defense and do an adequate assessment of its position. So with that, I thank everyone and close this webinar. Thank you, especially to Brian, for your time and expertise.
Thanks, Kay.